Hi, I'm Patrick Nugent with IICLE. I'm here with my good friend Charles Gardner, who's with Much Cellist in Chicago here. He is quite an expert in so many different areas, but also in the area of social media, and we're talking about social media today a little bit. And I guess when we really look at the whole of this thing, you look at what is it? What does social media encompass? How does social media, as a practice affect a lawyer and where?
Well, we're talking first and foremost, we're talking about ethics. So the first thing I'm going to say is I do not claim to be an expert in everything because the rules of professional conduct are quite clear.
So the first disclaimer is out.
The first thing I want to say is I am not claiming to be an expert at anything. However, I will concede that I focus a good deal of my practice on new media technology, social media in particular. I'm the head of a social media practice group, which I think is one of the first, if not the only, in the country. So
right.
You're correct about that. Social media is really for lawyers twofold in how it affects your practice. So just to be practical for a moment, you think about your own social media presence and what are you doing on your Facebook page, what are you doing on LinkedIn, what are you doing maybe in a lawyer blog or your website for your own law firm, and how interactive is that website? And then on the other side of the coin, you think about what are you doing in terms of practicing law? So what's the evidentiary value of the things that you can find in social media? And since we really are talking about ethics, what are your ethical obligations when it comes to being a diligent practitioner, a competent practitioner, the Rule 1 series of the Rules of Professional Conduct? What are your obligations there to investigate social media and to use it for your client's benefits? And I'd say, a tangent to that is, how are you using social media? And maybe this crosses both areas. How are you using social media to further the integrity of the legal profession and to reach out to communities who might be underserved by the legal community, and then to do that responsibly?
Mm-hmm. It's complex because essentially this division between the personal side of what the lawyer's doing can obviously cause problems. I'm sure even if we look and say, who are you friends with on your social media? Who are you linked in with? Who are your Facebook friends? Are they judges? Are they lawyers? This can affect you just from the personal aspect all the way up through the professional.
Right, exactly. And what you have to think about, I think, and that leads us really nicely into, let's talk about your own presence in social media as an attorney. And so now I'm not talking about what you're doing with discovery. I'm not talking about what you're doing with learning about the law. I'm talking about, you have a LinkedIn page.
Right.
You have a blog. You have a Facebook page. So let's look at those kinds of activities in three practical areas. First of all, what are you doing in terms of attorney advertising? I like to, it's the end of the rules, it's the Rule 7 series, but let's start there. Okay. The ARDC here in Chicago, has adopted primarily the model rules in substantially the same form as they exist, with some nuances. And there are rules that govern what you can and can't do in terms of advertising. So the first thing is, just being careful about your terminology, being an expert, specializing, right? We don't recognize fields of specialty, with a few exceptions. People who are admitted to the patent bar can say that they are admitted to the patent bar. In some jurisdictions, you can say that you're a certified family law specialist. But for the most part, we have to refrain from that. So what you're putting out has to be compliant. And I think that's pretty simple, and it's relatively easy to follow. I think it gets a little bit complicated for us when we're dealing with a site like LinkedIn, and I don't single them out. I think it's one that everybody knows. LinkedIn has a section that says skills and expertise, and then people endorse you. Right. And is that a violation of the rules? And I'm going to give you a preview, and I'm going to say that I don't think it is, and I'll be speaking down the road with Jim Grogan, and I think Jim agrees.
So you and Jim are actually teaming up on something that we've got coming up. I know it's our Social Media Institute, which is coming up. But
right. Yeah, and when Jim and I have spoken together and we go back and forth, Jim does have a tendency to think that I go a little over the top on being careful about this stuff. But when a site is identifying you in that way, it has a section that says skills and expertise, and somebody's endorsing you, provided that you're not soliciting that endorsement for consideration, because that's prohibited. I think it'd be a stretch, at least at this point, to say that that's a violation of the ethical rules.
However, on that site, you're able to actually list those areas that you feel that you have a certain amount of credibility in terms of what you're doing. So therefore, you're saying, yes, I'm good at public speaking. Yes, I'm a good real estate lawyer. Yes. So when you do get those, there is a little bit of a question there when you do get those. Oh, he's an expert at this, Well,
right. And so you just the rules are unchanged. I mean, there are some nuances and some things that have been recognized, but the basic rules are the same. Your lawyer advertising can't be false or misleading.
Right.
And an advertisement is false or misleading if it says something that's untrue, that's simple enough, or if it omits something that, when taken in the aggregate with the rest of your statements, would lead somebody to an untrue or unreasonable conclusion. So it's perfectly okay to say and you have to. I mean, this is the new media age, and this is how people are finding us. You have to be able to say, I practice in this area, I practice in the area of intellectual property and family law, in commercial transactions and real estate, whatever it is. But just as you would not send out a flyer that promised results, you're not going to put something on your website or your social media page that says, we guarantee, or 99% of our cases are resolved favorably, that's going to lead somebody to believe that you're saying, we can get you the same result as we've gotten in the past. And so the rules that you already know should apply to help you out in social media, but you'd be surprised how many practitioners just don't think that way.
Yeah, and it's what really is amazing when especially when you and Jim speak, which is so fantastic, is how many people don't even understand how much of a public forum this is, how much when you put this stuff out there, it's ownership for everybody, and therefore there's no privacy to this. If you're friends with a judge and you're making comments about something, you're both in trouble, essentially, if it's about a case.
Right, and in theory, that's absolutely true. So I don't mean to be a sociologist, but there are studies that sociologically, when people sit down at their computer, especially people who have a lack of privacy in their day-to-day life because of their office environment, kids especially, but that's a whole other bowl of wax, they tend to think that they're having private interaction, and even though we're certainly smart enough to know that it's not, we forget. So, yeah, who are your friends on Facebook? Are you friends with a lot of judges? Are you, and maybe it so happens that 30 people from your law firm have gone on and are now sitting judges, and maybe they weren't when you friended them on Facebook. It's been or whatever your social media page is. It's been long enough that could be a reality. But what happens when you're on the same case? It's not terribly practical, I would say, to scrub your Facebook page so much that you can eliminate the risk that any potential witness, any potential juror, any potential opposing counsel, any potential represented party, any potential judicial officer may not be on your page. So what does that tell you? It tells you that be careful about what you're saying in social media, and understand that there was an analogy that I'll talk about at the Institute. The social media is sort of like being in a crowded coffee house. I sometimes say like being in a crowded elevator. If you wouldn't do it there, don't do it in social media, right?
I like that. Getting to the other, the fact that we've taken the personal side of the fence, we're taking the business side of the fence. Let's talk for a few minutes just about social media and how it actually applies from the perspective of what you're doing in your business, how you're doing discovery, how you're utilizing it, if you are utilizing it, and if there's pratfalls and problems in the way that you actually utilize it.
Right. It's a double-edged sword, because there's a case out there that I like to quote. I think it's Griffin versus Maryland. I'll be embarrassed if I'm incorrect. But basically, the judicial officer in that case said, It is now a matter of professional competence to use social media in your investigation. Well, that's a powerful statement. I mean, that's I think Rule 1.2, that's one of our first duties, right? And diligence, also in the Rule 1 series. These are our first duties and the first thing that we're supposed to be thinking about. The American Association of Matrimonial Lawyers, I think they put out a study that something like 85% of family law attorneys are using social media in their investigation. So that says two things. How are you using it? Are you using it properly? Are you using it for a proper purpose in a way that doesn't invade people's privacy? Right? There's candor before the tribunal. There's fairness to opposing counsel. There's fairness to unrepresented parties. You can't just be going out and mining for information that may have no relevance, that could be salacious, that could have an impact on your case, and then try to get it admitted as evidence. By the same token, if you're representing somebody, and I'll use a simple example, a disability case, right? And you're representing an insurance company, and there is just widespread social media out there that whoever party A is, who claims to be out on disability, have a broken leg, can't walk, and there's pictures of them hang gliding in Hawaii or Costa Rica, and it's all over the place, and you didn't find that. I think we're coming to a place where, as attorneys, that could potentially be an ethical violation, and that's really something to think about.
So you end up in this really kind of on the blade in terms of the fact that, hey, if I use this and I use this incorrectly, I'm liable.
Right.
Or if I don't use this in a discovery situation where I know that I can get, where I can have a better result for my client, I could be held liable. So it's, I guess for all of you in the social media world, are you saying to yourself, is there a win-win to this?
Well, and the answer is it doesn't really matter because it is what it is.
Right.
The social media is the wave of the future, the next generation, and I think social media is almost going to become an antiquated term. We have this global society that communicates via the internet, regardless of language barriers, regardless of disabilities, and that's one of the really positive things about social media is your ability to reach alternatively abled clients who might not have access to legal services. My friend Rachel Arfa, who's with the Midwest Center for the Law and the Deaf.
She's also going to be an instructor in this course we're talking about.
Right.
Yeah.
She talks about how this has really opened the door for, in this instance, the deaf and hard of hearing community to have access. And one of the things that I don't want to harp on the program, but one of the things that we're doing that I think everybody should be doing is we're going to be I should know the proper term, but we're going to be captioning, in real time the program so that it is more available to the alternatively abled. And that's something that's now really easy to do in social media. You can have a conversation with a deaf client, of course, by instant chatting, but there's programs coming out that will allow somebody to enter something in and it come up as words or come up as sound. So you could have a blind attorney representing a deaf client, and now they're able to communicate, and that's phenomenal.
And I think the other beauty of it is the fact that, I used to look at these things like, okay, well, we're going to do, like we're doing the Social Media Law Institute, which, by the way, when we're talking about some of these wonderful speakers that we're going to have, we're going to delve into these issues and how this actually really, truthfully affects lawyers, not just lawyers, affects clients, and will and does or doesn't raise the bar for all of the practitioners in the state and across the country. But I look at the conversation sometimes, and I think we used to do a course, and then a year later we would do the course again. There was no dialogue that was going on throughout the year. One of the beauties that I see in this particular avenue when you're reaching out to veterans or deaf people, or you're reaching out to a community that maybe doesn't have access to this is a way of keeping a dialogue going between people that are actually committed to the conversation, as you put it, all throughout the year. And it's an ever-growing way of saying, as we come to these things each and every year, we've learned a lot of things because we've kept this conversation going between each other.
Right, and it does two things. Again, it's not only about your being able to do that with your clients, but it's also about us being able to do that as attorneys. And I don't recall her name, and I don't want to plagiarize from her, but there's an attorney whose blog I was just reading, and she was talking about the 12 pitfalls that attorneys can get into in social media. And look, I lecture on this, once a month, twice a month sometimes. I write about it, but I'm still out there reading things, and she came up with something that I really hadn't thought about, and I think I'm going to talk about it at the Institute, and I promise I'll give her credit there. But just an example, when we talk about advertising and solicitation, let's think about Twitter. So your prospective client, and anybody who's out there is a prospective client, so the rule applies, and you got to think about it. You're on Twitter, and you happen to be following 1,000 people. You probably don't know all of them. They're probably not all your best friends. And all of a sudden, you see somebody send a tweet that says, darn, I just got busted for a DUI. And you immediately send a response that says, I'm a DUI attorney, and I'll give you my social media discount. Well, that's real-time solicitation of a client. And that's a problem, and that's a violation of the Rule 7 series. Right. On the other hand, if the person tweeting said, is anyone out there an attorney who can help me? Well, now the client's initiated the contact, and probably it's not a violation of the rule. Mm-hmm. So there's some real nuances out there, and you're right. The fact that we can have a dialogue as attorneys doesn't just give us the chance to talk to our clients, but it gives us the chance to talk with each other about how we can uphold the integrity of our profession.
Which I think is just unbelievably fantastic and relevant to the fact that, that's, for one thing, that's the way we raise the bar for lawyers in the state of Illinois. For another thing, in this particular subject matter alone, you can sit with three people and have three completely varying opinions about what you're saying at a cocktail party to somebody in terms of how it can actually affect your business and how it can affect what you're doing ethically through some of these resources.
And even when you're having that conversation, which you should have,
right.
Are you inadvertently violating your duties of confidentiality? Or the rules that bar trial publicity, or a court order that might bar trial publicity. And I'll talk in my talk about cases where attorneys have been dinged for just that, for giving out information that in the aggregate, they were just trying to talk about their day. In the aggregate, it reveals the identity of their client or a confidence of a client. And that's a huge no-no that we would never do in the real world.
Right, right. Well, this is going to be, a fantastic opportunity, and almost all lawyers are delving in this one way or another, whether they know it or not.
That's right.
And I think that what you guys have done here in trying to put together this institute is just to be commended in the sense that I think we are trying to be at least ahead in that conversation. And in that ever-changing arena of how this is going to affect lawyers on a daily basis, this is something people really got to get into and see.
Right, and to have the conversation in a way that is appropriate for the media. So it's not just, you're going to have Jim Grogan and I talking about ethics, and Neil Posner, who's also with Much Shellist, and Wendy Muchman, who's also with the ARDC, also talking about ethics. That'll bookend your day. But we've got a social media marketer, a word-of-mouth marketer, Mike Pillars, who's going to be talking from the practical side with me moderating. How do the rules, so FTC rules about .com disclosures just came out. And you may remember that when we did our program last year, I said, consider the traditional notion of payola plugola and how that applies in television. You can't put a can of Pepsi, for example, that you're paid to put on the set without disclosing that you've had consideration. And I said, that's going to come to play for attorneys, not just in representing their clients, but themselves in their blogs. And sure enough, last month, the FTC came down and said, by the way, effectively, the payola plugola rules that apply in other kinds of media apply to you in social media. And they put out a 43-page brochure on .com disclosure that Mike will talk about, that I'll talk about a little bit. And all of a sudden you have to be thinking, well, what is the pecuniary interest in my blog? What about the fact that I'm paid by a client? Am I talking on a client side? I mean, there's a real host of issues that are coming up faster than I think almost our brains can comprehend them, or at least my brain.
Well, I think you have a fantastic brain, and I love the fact that, immediately out of the gate you're able to, with just through my language, you're able to say, I've got disclaimer number 1 on the table, Patrick. And, and how do you safeguard yourself there? I mean, you were talking to me about some of the things that, that even Jim Grogan says, I think you're getting a little bit carried away here, but you do try to safeguard yourself in terms of what you're doing.
Well, I pride myself. I have a client who I recently wrote a cease and desist letter for. That the client said to me, and this client is known for being tough, Charles, maybe we want to tone it down a little bit. And I think it's kind of like that when Grogan or Wendy or somebody from the ARDC, or I talk to bar counsel, all over the country, and when they say, wow, well, that may be a little bit of a stretch. So I'll just talk about myself, right? I have 3 separate paragraphs of disclaimers on my LinkedIn page. And the first thing I say is that this is not legal advice. Right. This doesn't represent the opinions of my law firm, because I like my job. This doesn't create an attorney-client relationship, because the prospective client should know that their communications with me aren't confidential. They should know that they need to consult counsel in their jurisdiction, because I may be talking to somebody in Iowa and I'm not licensed there. And then part 2 of my disclaimer, and this is where some people say that I get a little bit over the top, I like to say that nothing herein is meant to be attorney advertising. That and simply by virtue of saying that, and that keeps me honest about how I present things. That means that I can't just say it, as I said before. I can't say something that gives people the reasonable expectation that they're going to have, or really an unreasonable expectation of similar results. And then I go to even a third level, and this goes to what we were talking about with what happens when, and maybe it's less likely on Facebook, but let's think about a family law forum or an intellectual property forum that maybe 20, 30,000 attorneys belong to. Right. And we're in the middle of a trial, and something is posted there by another attorney, and I'm a member of the forum, and or by a witness, or by an adverse party, something that if I had learned of it in any other context, I'd be charged with knowing it, and there'd be ethical obligations on me for either screening myself off or for making a disclosure about what I know. But just by virtue of being in the same chat room. Right. So I say, while I may be a member of this forum, you should not assume that I read anything or everything that is posted here, or that I have any knowledge of it. And if you want me to know it, say it to me directly.
Before you actually, so let's say you get in one of those forum dialogues. So we've got the New Lawyer Advantage, and we actually inspire some of our mentor teachers to actually follow some of the new lawyers so that they can help drive discussion. Do you put that disclaimer in the advent of actually joining that group on LinkedIn or whatever?
Well, so far, in the forums I'm in, and another thing that I do is I limit the forums that I'm in to the extent they're interactive. I mean, there are some that I really practically want to belong to, and I do. I like to be more of a passive observer, and then when I'm going to be an active participant, I'm much more cautious about where I am and who else might be there, and I'm also not a litigator, so that helps, but it doesn't alleviate the responsibility. But LinkedIn, for example, has a section that is about you, right, about me. Facebook has a similar kind of thing. So I guess it probably makes me appear to be the most boring person in the world, that if you go to the section where you want to read about what baseball team I like and what soda pop I drink, you're going to get something that says, nothing herein is intended to be attorney advertising. This does not create an attorney-client relationship, and you shouldn't assume that I read anything. But that's what I do, because I don't want to have to do it every single time I post something.
Got it. It's amazing, and I mean, and even what we're doing with this, where, you and I were talking about the fact that with our IICLE TV pages, what we really like to do is, without an advertisement, offer the lawyers some content, which, by the way, this is a great conversation, and there's a tremendous amount of content here in this. But at the same time, then I'm going to say at the end of it, don't forget the fact that, on the 21st of June, we've got this Social Media Institute coming up with all of these great speakers, and so now obviously where's the black and the white to that, right?
Well, right, I'll preview something that I'm going to talk about, or something that you'll read about if you look at ethics and social media, the pretexting. Right? So that's one of the things that is an evidentiary rule problem, right? You can't go investigate someone's Facebook page when they've got their settings set to private by, say, having your non-lawyer assistant friend them.
Right.
And then all of a sudden you have access to all this information that's private. That's called pretexting. And the Philadelphia Bar put out an opinion that said that's an absolute no-no.
Yeah, and I've heard Jim actually talk about a couple of cases here in Illinois that this is exactly the modus operandi that they did. They said, listen, you go do this, you get in the door that way, and then I'll take that information.
So you have to think about that in terms of you really start to think about the rules of evidence, right? The federal rules of evidence, the Illinois rules. Think about what's admissible. Is it relevant? Is the risk of prejudice, outweighed by the beneficial factor of the evidence that you're presenting? Was it properly obtained? Is it, can you verify it? Can you authenticate it? Did you see it on Facebook and print it up? How do you know that the person whose Facebook account that's supposed to be it is? So there's a whole procedure for that. You really have to think along those lines and be mindful, and I say it really goes back to the integrity of our profession, and then there's places that you can go. So there's a site, and we're going to have a speaker from the general counsel from AVO, which is a site that ranks lawyers and rates lawyers based on public information. And I was a little bit disconcerted when I first found out that this was happening, and then I realized but this is the way people are learning, and this is the way people are finding out information. So sites like AVO allow you, and not just them, any similar site, it allows you to maybe go out there and answer questions that people might have, and you've got your language up there that says this is not legal advice. I still, if I answer a question, say I'm not licensed in your jurisdiction, you should talk to an attorney. But then it begs another question of what's being said about you as an attorney in social media, and when do you have to accept that that's the way of the world, and then when is it something that you can or should respond to? And Josh King, who's the general counsel there, is going to talk at the Institute about how do you handle a negative review. There was a case that came down recently that in responding to a negative review, the attorney got sanctioned for violating Rule 1.6 confidentiality because it was impossible for the attorney to respond without admitting that I was the attorney in this case and I have information and I'm disputing or not disputing.
It's fascinating. I mean, we could sit here for an hour and a half, and continue this dialogue. We're inviting all of you, by the way, to join us in this dialogue. It's on the 21st of June downtown at the UBS Tower, which is right in the heart of downtown Chicago. Very accessible, but we want you to come and be a part of this dialogue. Some of this stuff, as we're talking here, we will have like an amazing platitude of opinions and ideas that are going through this, but this is going to be something that's not going to go away, and this is going to be something that I feel like next year we'll be talking about this in the same fresh manner that we're talking about it this year.
Next year we'll be talking about all the things that we didn't even think about this year.
Right.
Right. And it's right. It's going to be webcast, right?
Yes.
So when did we have it? 6 years ago, 7 years ago, it wasn't so easy to learn and educate yourself, let alone get your CLE credits without leaving your house, or if you're an Illinois attorney in another jurisdiction. And again, that all goes to why social media is so fascinating, so relevant to us as attorneys as people and attorneys as practitioners. And I hope what we're going to do, because we really do have a diverse panel, it's not just lawyers, and the good news is I'm only one of the speakers, so my mouth will stop at some point. You know, that we're going to be able to show that broad perspective and yet still talk about the things that matter to us as practitioners and go to the integrity of our profession.
Well, you know what matters to me, which is the fact that we are the most fortunate company, in my opinion, that we have a vision of maintaining a high degree of content and excellence and practical guidance for lawyers. We have a vision of actually allowing those lawyers to go out, better serve their clients, to raise the bar for all the attorneys. And let me tell you, the way that we do that is we have people like you that come on. Wow. Your hard times, your knowledge and your sharing of that knowledge as volunteers at IICLE, we just have the best, in my opinion, volunteer base of lawyers going out and saying, we need to help. We need to be mentoring. We need to say we're going to be a part of the community that's going to help teach, learn, and raise the bar for, and the networking, and raise the networking availability for lawyers.
Well, and that is, it's very kind of you to say, one, and two, it goes to something that, you know, led to why I went from in-house to a law firm practice, and really, in the middle of my career, I thought, social media is here to stay. I mean, there's no doubt about it. The next generation is going to be in control, and the good news is, for IICLE, it keeps you, not that you wouldn't be in business, but it certainly keeps you in business because there's never going to be an end to the amount of knowledge that you can impart and the things that lawyers need to learn about. For me as a practitioner, and I think more importantly for younger practitioners, this is really about the legal profession staying relevant. The social media world doesn't always follow the rules that we grew up with and the laws that we grew up with, and they don't necessarily have an understanding. And we can either close the door to our law firm and say it shouldn't be like this, and I'm going to stick to traditional means and let the next generation come up in anarchy. But I really do think, without meaning to wax philosophical, that there's a higher purpose in people my age and older, and even younger now, going out and talking to younger attorneys and being a part of the social media community so that we can apply the principles of law and democracy in a way that works for their community and still infuses it with some of the democratic principles that we've come to rely on. And I think that's our duty, and for me, being invited and so kindly invited to do this, it keeps me relevant and it keeps me alive, keeps me alive as a practitioner and as a person. So I'm thrilled at the opportunity, and I greatly appreciate what you do.
Thank you, Charles. I want to thank Charles for being a part of this. We hope we're going to have you all engaged in this amazing dialogue throughout the year, especially come and join us on the 21st of June this year at the UBS Tower for our Social Media Law Institute. Thanks again.
Oh, my pleasure. Thank you for having me.